Good afternoon. I'm Judge Tammy Long Hayward. This is the civil calendar for June 4th, 2025, Clayton County State Court. I'm going to call the calendar. Health as Surviving Parent versus College Park Retail, Jailus Inc., Hale Retail Group.
Good afternoon, Your Honor. I'm John Christie with my colleague Jamie Christie here for the Move-Ants, Hale Retail Group, LLC, and Jailus Inc.
And Alex Brown and my partner Mike Rafey here on behalf of the plaintiff.
Malfred Colley versus Gregory Lee Crooks. Malfred Colley, Gregory Lee Crooks. All right, is Catherine Sherry, did Ms. Sherry send in a conflict, Ms. Powell? All right, so the motion will be dismissed for want of prosecution. Next is Moore, a minor, Morris Moore, Adela Trejo, Fabiola Trejo, Jimenez, a minor, Amy Alvarado as administrator versus Pressbrook Insurance.
Good morning, Judge. My name is Heath Brooks. I'm here with co-counsel Will League and J.L. King as well for the plaintiffs.
And Mark Bardak, Mark Bardak of Freeman Mathis and Gary for the defendants, Your Honor.
Judge, I'm in a different Zoom than co-counsel League and Brooks, but J.L. King here.
All right, next case is James Lee John, Future Management Corp., Delta Star Corporation.
Judge, that's the same case.
Oh, it continues. Oh,
Just got a lot of parties.
All right. North America Wells Fargo Bank versus Phillips Shadaru.
Good afternoon, Your Honor. Alex Capers on behalf of the plaintiff.
Philip Shadaru. Okay. Wells Fargo versus Leonard Lowry.
On behalf of the plaintiff.
Leonard, yes, I'm here.
All right.
Present.
All right, next is Wells Fargo versus Quayshawn Ivy.
Good afternoon, Your Honor. Sade Clark for the defendant.
All right.
Your Honor, is that my case as well? I didn't have that one on for the day, so.
I don't know. I can't tell you if it's your case.
It is. Ms. Capers, it is.
Okay, sorry. I just didn't have that one on my doc. So who's the first and last name?
Quayshawn Ivy, I-V-E-Y.
Okay. Okay, we filed a notice of settlement in that case. It looks like the parties have reached terms, so I apologize. Our office thought that this case was off the calendar.
All right, Ms. Clark, are you, you're clear on that?
Yes, Your Honor.
So the Wells Fargo versus Quayshawn Ivy matter has been settled. Even when they're settled, sometimes there's stuff for me to hear, so I always want to make sure I'm asking the questions. Next is Bank of America versus Hassan Kashaka.
I'm Hassan Kashaka, Your Honor.
Anyone here on behalf of Bank of America? Last call, Joseph Cooling, Nikita Adita, or Aditya, Richard McCarthy, Louis Feingold, Scott Peskin, Louis Chiappa, Robert Winter.
The password.
I'm sorry. Hello? All right, so none of those parties appearing. Mr. Kashaka, do you have anything that you're asking for, or was this, you were here because of the contract?
Here because of the contract.
All right, so none of the parties on behalf of the plaintiff have appeared, so the matter will be dismissed for warrant of prosecution.
Thank you, Your Honor.
You're welcome. All right, UHG 1 LLC as assignee versus Leonce White versus City of Riverdale. So this looks like a garnishment action. Mr. Victor Newmark, on behalf of the plaintiff. All right, anyone here on that case? UHG versus Leonce White versus City of Riverdale.
My name is Leonce White, and I'm representing myself in this action.
All right, Mr. White, were you asking the court to reconsider something about this case?
Yes.
Okay. What were you asking the court to consider?
Do I have time?
Well, here's the thing. Certain things on a garnishment I can hear, certain things I cannot. If you are challenging the underlying judgment, I'm not the person for that argument. If you are challenging, I'm
yes,
sorry.
ma'am. Excuse me, Judge. My apologies. I am challenging the judgment.
Okay, so you have to challenge the judgment where the judgment was issued and with the judge issued the judgment. Now, if I am that person, then it doesn't come as a garnishment action. It comes as a challenge to the original case. Garnishment cases get new case numbers and they're a new case. A judgment action will have the case number for that action. So if you're challenging the underlying judgment, then you have to do it in that case. But for garnishments, it generally means you're challenging either how much money is being taken out or like some other form of the distribution of funds from your salary or wages. Okay, so if you're challenging the underlying judgment, this is not the appropriate place for that. Okay.
Okay.
All right, so that will be dismissed as to the challenge to the garnishment.
Oh, wow.
You understand what I'm saying?
No, ma'am.
Okay. So garnishments and judgments are separate actions. You get a judgment when they first come to a court and say, hey, this person owes me money. And judge, we wish to have the money, we wish to have a judgment for that money so we can collect the money. That's one action. Once the judgment has been given and the court says, yes, they owe you money and you can collect on that, then they can pursue it through a garnishment. Not every collection ends in a garnishment, but some of them do. That means they go to your source of your wages to seek payment from the source of your wages. So they'll go to your job to ask for money to come out of your check. That's a separate action. So if you're challenging the actual judgment where the court said, oh yeah, you owe this money, you got to go to that case.
Okay.
right?
Question is this, we've already gone to court twice on this in the county where I reside, and
Okay.
both times
If
they
the
were not
Sir, if the judgment was
plaintiffs.
found to be valid, then there's nothing you can do about that. Now, unless you're challenging the way the money is distributed from your employer, you can't challenge you just because you challenged it twice and lost doesn't mean you get to do it again here. It means that that judge felt like he did the right thing.
Okay. But it was in reference to providing documentation that they were never able to provide. And now we're here in a new jurisdiction and they were granted garnishment. I'm not understanding that.
Okay, I've done as much as I can do to explain it to you. You may want to seek counsel of an attorney.
Okay.
All right. All right, so the case is dismissed at this time. So I'll deny what we call it a traverse. So I'm going to deny your traverse because it's not really a traverse. And then whatever you want to pursue otherwise, that's on you. But this is as far as this can. Okay. All right. So let's go back. All right, if we can take a couple of the smaller collection cases, which may be defaults, then the ones that are going to take a lot more time for argument, we can get back to those. So if I'm not currently speaking with you, please make sure that your device is muted. Okay, so let's Wells Fargo versus Shadu, I'm sorry.
Yes, Your Honor. We filed a motion for summary judgment in this particular matter. It does appear that the defendant filed an answer which amounts to a financial hardship. So we move for summary judgment. There's been no response to the motion. So I'd ask that the court just rule on the pleadings. Damages are liquidated.
All right, and you filed the affidavit?
Yes, ma'am.
Okay, have there been any changes to the amount pled for?
The amount is pled for and the motion for default judgment is still the balance as of today.
All right. So the court, the case, the defendant was served, filed an answer. The answer essentially alleges hardship, which is not grounds for denial or does not present a genuine issue of material fact. So the court is going to grant the summary judgment in favor of the plaintiff in the amounts pled.
Thank you.
All right, Wells Fargo v. Lowry. Mr. Lowry is present.
Your Honor, the defendant did file a response in this particular matter. We have also moved for summary judgment. This is based upon a credit card account. I can lay out the motion if the court wants it on the record. However,
Yes.
I intend to rely on the pleadings. I do not believe that any of the affirmative defenses that were raised in the answer show that there's a genuine issue of material fact left for the court to decide. But I have not had the opportunity myself to speak with Mr. Lowry, and I don't see a response to our motion for summary judgment filed on his behalf.
All right, so Mr. Lowry, I'm gonna allow Ms. Capers to put her case out here about what they're alleging that you owe. But you also have the opportunity, the option, if you wish, to speak with her if you believe you owe something or you wish to talk about terms of payment. You may wish to speak with Ms. Capers in a breakout room. And if you all can agree upon something, then that would be fine with me. The court will go ahead with whatever you all agree upon.
I guess I'll take the opportunity to speak with her, but there are a lot of things that's not presented from the credit card.
Okay. So do you wish
yeah,
to go ahead and have the hearing?
I guess I can speak with her first before we have a hearing, I guess.
All right, Ms.
I'm not,
Capers, are
I'm
you?
not, I'm not really sure on how this represent, when I spoke with, Wells Fargo a while back, it's supposed to go through another process and then this pops up, so I don't understand.
Okay, so this is the issue that a lot of people don't understand. So when they're pursuing a debt, they can talk to you about the debt, but they can also file a suit. And so while they're talking to you, they can also be filing a suit, and you need to respond to the suit while you're talking to them. And a lot of people,
Okay.
because they don't have an attorney, they want to do it themselves. They don't understand that even though you are talking to them, the lawsuit process is still ongoing, and you did file an answer. So
Yes.
maybe there's something you all can talk about with respect to how to resolve payment, because it sounds like your answer does not mean that you don't owe anything.
I don't owe this amount at all.
Okay. All right.
That's for sure.
Because
Yes.
this motion has been pending for almost a year, I do want to go ahead and put it on the record so that the court has it. I'll be happy to speak to Mr. Lowry, but if we aren't able to work it out, I'd like the court to issue a ruling on the motion.
All right. So Ms. Capers, go ahead and lay it out for me.
Yes, Your Honor.
So Wells Fargo initiated the account for the credit card. It's not an assignee, correct?
That is correct.
Okay, go ahead.
So Mr. Lowry entered into a consumer credit card agreement with my client. They are the original creditor. Based upon the documentation as filed with the complaint, we show an outstanding balance of $26,906.70. In addition to that, my client is seeking the court costs and attorney's fees associated with the file. However, they've asked the court to cap the attorney's fees for this file at $800 even. Based upon the answer that was filed, it was a generic answer of general denials and affirmative defenses raised. However, none of them present a genuine issue of material fact for the court to be left to decide whether or not this balance is owed. Based upon the rules of Georgia law, there was a credit card agreement entered into here by the usage of the card. There were payments made on the account, and an outstanding balance remains unpaid. There's been no evidence submitted by the defendant to the court to show that there is a different amount owed. And I'd ask that the court grant it based upon the pleadings as filed and the evidence submitted into the record.
All right. So, Mr. Lowry, the record and the statement made by Ms. Capers indicate that you took out a credit card from Wells Fargo, that you used the credit card, that some payments were made, but not all payments. And once the payments were stopped, then an amount accrued of $26,906.70. If you have evidence that you made payments that would reduce that amount or erase that amount, then you need to present that evidence.
I do not have evidence of erasing that amount. But my credit limit on that was only 10,000, so I don't know how it went from.
Ms. Capers, I don't do consumer law. I don't do any law other than presiding over the law. So you want to explain to Mr. Lowry how that can happen?
Yes, Your Honor. Pursuant to the terms of the credit card agreement, if he does make purchases over the limit, he will be charged over limit fees. In addition, those charges will be allowed to be made. He will just suffer the consequences of going over his exceeded limit. And if you look at the statements as filed, it says that his over the limit amount is in excess of $16,000. So he is correct. It does appear that he went over his limit with his spending on this credit card.
Are there any other amounts that might have been added to the account based on maybe late fees or any other penalties or anything that you can explain to Mr. Lowry?
Yes, it does appear that there's an interest rate accrual on this account, and every time a payment is missed, a late fee is also associated. So it looks to be, I believe I saw the interest rate.
Because interest rates on consumer debt are really high.
Yes, they're typically in the 20 percentile. No, I can't see no. Find it on this. Statement. I see what the interest amount is for the year.
So sometimes, Mr. Lowry, you will get what is called an introductory interest rate, which might be pretty low to introduce you to the debt. But after a certain period of time, then the actual interest rate comes in, and those tend to be in the mid to high 20s, 25, 24, 23, 26.
I understand that, but again, my payment, my limit was only 10,000.
I get that, Mr. Lowry, but she's
that wasn't.
explained that they were willing to accept and pay on your behalf for over the amount of the limit. So that the limit works for them, not for you. So they can limit you, but if they want to extend it, I guess they did in this case.
Yes, Your Honor, and that's
It doesn't limit your debt to $10,000, is what I'm saying.
Right, but it was never extended that much, is what I'm saying.
But
it was never extended.
I can read the
Hold on, Ms. Capers.
to you.
Do you have proof of that, Mr. Lowry?
I do not, because I was never given no, I don't have any proof of that. It's just what the contract is. My limit was $10,000, and it went all the way up.
That.
But yeah.
But you would have received credit card statements, correct?
Yes, and I spoke with them about that constantly.
Do you have any of those?
Of the statement? No, I do not.
Okay, so
no.
I'm not sure. Like you're asking me to do something, but you don't have evidence of what you're asking me to do. You're asking me to limit the amount to $10,000 because you said that was the limit of the credit card that you took out. But they said they've explained that they've allowed you to charge more than that. And then there was interest and penalties that came with that. And I'm asking you now we're going back to you to tell me what proves that you're at a $10,000 limit.
That was I can't prove that because I was discussing that with them, but I know I cannot prove it. Be honest with you, no, because I never charged over that amount is what I'm saying. I never charged over that amount. There was activities on the account that I was speaking with them about, and
you don't have any of your credit card statements available?
No.
Okay.
No, I just know what that moment was, and that's what it is.
All right. So, Ms. Capers, did you have an amount and damages that you wanted ordered?
Yes, Your Honor. The amount is listed on the pleading. So it's the amount of $26,906.70. Court costs of $306.49 and $800 in attorney's fees.
Okay. All right. So the court is going to grant the plaintiff the amount of $26,906.70 in principal. Court costs $306 and attorney's fees capped by contract at $800. Mr. Lowry, you'll get a copy of the court's order. If you wish to, at this time, I guess, continue to speak with or negotiate with Wells Fargo, you may do so at the information that you currently have, okay?
Okay.
All right, thank you, sir.
Thank you, Your Honor. May I be excused?
You may, Ms. Capers.
Oh,
wait, no. I want to check and make sure I've gotten all your cases.
Yes, I was going to say I had two, and then the other matter with Ms. Clark was settled, but I think she had a question.
Yeah. Yep, I think we're, Ms. Clark, did you have a question?
I just wanted to know if I could be excused, Your Honor.
Oh, yes, ma'am. I'm sorry. You could have been excused before.
No worries. Thank you.
Okay, yes, ma'am. All right. So just trying to go through the cases that I have.
So will I be able to speak with Ms. Capers?
You can call them like offline. So the case is the judgment has been granted. So it's best to deal with them with the office when you got an opportunity to speak with them, because the breakout room will end as soon as we're finished with these cases. So
Okay.
you can gather, and then that way you can gather whatever information you might still have in order to be able to still negotiate with them.
Wow. They really, this was, okay.
Mr. Lowry,
right.
I hate to say it, but this is your trial date. So when you come before a court, you need to have all of your documents ready. If you get a court notice, that means that's the time to have all of your stuff ready. We
Right.
can't tell you that because we're not your attorney, but why would you ever come to court without whatever it is you're saying that you want the court to take notice of? You got
Okay.
me? Okay.
Yeah.
Thank you.
Thank you.
All right. So let me see. You've gotten the money cases, the default cases out of the way. We have Huff versus Hollows and Hale. We have Colley versus Crooks. Okay. And Moore et al. Versus Crest. Okay, so let's start with Huff. Did anyone show for Colley versus Crooks? I don't believe so. Yeah. Okay, so let's start with Huff. All right, Huff and Surviving versus College Park Retail. They've been dismissed. It looks like, is it Jollis or Hollis?
Jollis,
Jollis
Judge.
Inc. versus Hale Retail Group. All right.
All right. Good afternoon, Your Honor. I'm John Christie here with my colleague Jamie Christie. We represent the Move-Ants. Move-Ants are Hale Retail Group LLC and Jollis Inc. Also on the Zoom call is Mr. Antonio Santos, who is the principal of Jollis Inc. And also Mr. Sam Hale and James Hale and Adam Smith, who are the principals of Hale Retail Group. This is a motion brought by the defendants pursuant to OCGA section 9-11-55B to set aside a default and a judgment of liability entered by the court on March the 26th, 2025 in this case. This is a serious premises liability case involving the death of a young man. The Hale Retail Group was the property manager for the property. Jollis Inc. is the property owner. The plaintiff is the decedent's mother in both her capacity as the survivor of the decedent and the administratrix of his estate. The default arises from the fact that in March of 2024, the complaint was served upon the defendants. The evidence that's in the record through the affidavits of Mr. Hale, Mr. Sam Hale, Mr. Jeremy Borak, show that upon receipt of the summons and complaint on March 24th, 2025, the defendant, 2024, I'm sorry, March 24, 2024, the defendants immediately sent it and forwarded to Mr. Borak, who was their insurance agent with the Baldwin Group. Mr. Borak then had a telephone conversation with Mr. Hale, Mr. Sam Hale, in which he acknowledged that upon receipt of the summons and complaint, he would forward to the traveler's insurance company, the defendant's insurer, for defense. In Mr. Hale's affidavit, as confirmed by Mr. Borak, the summons and complaint was indeed sent to Mr. Borak, and he acknowledges having received it. He also acknowledges having provided assurances to Mr. Hale that the summons and complaint would be forwarded to the traveler's insurance company for defense. And subsequently, he just didn't do that. And so as a consequence, in March of 2024, about a year later, when the plaintiff finally moved for the entry of a default, the court entered its March order. When the defendants received that order, they promptly took action to file this motion pursuant to OCGA section 9-11-55B to open the default. As I said, Judge, this case is a premises liability case, which is affected and impacted some by the changes in the tort reform and the premises liability law recently enacted by the legislature. So not only is it a serious case because it involves the death of a young man, but it also implicates serious and important issues of Georgia law, namely the application of Georgia tort reform.
So I get it. Let's test the new law, but my my default when entered was valid because y'all didn't perform. So why aren't y'all suing Mr. Borak? Why are y'all coming back to me to open up this case instead of suing the person who failed you?
Well, Your Honor, because we have a right to assert our meritorious defenses and to defend this case, and also to vindicate the longstanding Georgia policy and Georgia law, which favors opening defaults and deciding cases on the merits. The Georgia Court of Appeals has expressed on numerous occasions, including in the case of Kegler versus Atwell, 251 Georgia Appeals 270, that the rule permitting opening of default is remedial in nature and should be liberally applied. For default judgment is a drastic sanction that should be invoked only in extreme situations. Whenever possible, cases should be decided on the merits, for default judgment is not favored in the law. In addition, courts have routinely stated and repeatedly stated that a litigant should not be unnecessarily forced into default as a consequence of having reasonably relied upon the word of his fellow, in this case, Mr. Borak, and his company, especially when no innocent party will suffer if the default is open. We've moved pursuant to 91155B, Judge, to set aside the default. That code section provides 3 separate independent tracks for opening defaults, which include providential cause, which is broad, excusable neglect, which is even broader, and where the judge from all the facts determines that a proper case has been made. In their reply, the plaintiff does not argue that we haven't complied with the predicate for 91155, namely paying costs, offering to plead in stanter. What they argue is that we have failed to establish excusable neglect or a proper case. Indeed, as I'll explain to the court later, they haven't even argued prejudice in this case. In fact, if the default is not open, they will be prejudiced because the defendants will have no insurance coverage. Now, with respect to excusable neglect, plaintiffs rely primarily on the case of Flournoy versus Wells Fargo, 289 Appeals 560, 2008 case, in which the court, they claim says that, well, we didn't report the claim to our insurer, we reported it to our broker. Now, they also claim that our affidavits are self-serving and we didn't bring Mr. Borak to testify. Well, we've filed the affidavit of Mr. Borak, in which he confirms, as I said, the affidavit testimony of Mr. Hale. This complaint was indeed sent to Mr. Borak virtually at the day after it was served by the process server. That Mr. Borak assured the defendants the case would be forwarded to Travelers, the insurance carrier, for defense and handling. So they were diligent. They sent the complaint, as is customary in the property management business, to the insurance agent / broker for forwarding to the carrier for defense. They were assured that the case would be handled and defended, and that simply didn't happen. They are the victims, the innocent victims, you're right, of Mr. Borak, but they still have rights. And there may be issues that there's no claim against Mr. Borak for which they are entitled to assert those defenses. I might also point out the facts of this case are distinguishable from Flournoy, because in Flournoy, the defendant's lawyer said he never got the complaint. So he couldn't have sent it on to be defended or defended it because he never received it. In this case, Mr. Borak admits he got it and simply didn't forward it. So, moreover, I should add the case of Patterson versus Bristol, which is 286 Appeals 423. The Court of Appeals found that reporting the suit to the broker who assured the defendant that it would be defended is adequate. You don't have to report it to the insurance carrier. We would argue, to Your Honor, that we have met our burden on excusable neglect because we have demonstrated that we timely submitted the case for defense. We were assured it would be defended, and it was not. We've satisfied that legal standard. But alternatively, and perhaps even more with greater applicability, is the proper case standard. Deciding whether or not there is a proper case to open default turns on each case's unique facts, which is why in their reply brief, they've got a number of a string side of cases in the brief that seem to go in all different directions, because each case is unique and has to be decided on its peculiar set of facts. No two cases, the fact pattern of no two cases are alike, and the purpose of this ground, proper case ground for setting aside defaults, is to have cases decided on the merits in the interests of justice and to avoid injustice. Now, the Supreme Court has defined very clearly what this proper case standard is in Bowen versus Savoy, a 2020 case. And they held in that particular case, the proper case standard, unlike the excusable neglect basis, we're not required to show a reasonable excuse for failure to timely answer. That is not a requirement of this. Instead, the Supreme Court instructs the trial courts to consider all the facts when assessing whether a proper case has been made out. And that proper case permits the reaching out in every conceivable case where injustice might result if the default is not opened. That, again, the essence, and we'll get back to this much like in the federal standard, which Georgia is migrating toward, the essence of the proper case ground is the broad discretion of the trial judge to ensure that there is no injustice and in keeping with the policy of deciding cases on the merits. And that's what's key, the case being to be decided on the merits. The Court of Appeals has set forth various factors for the court to consider, whether the opposing party be prejudiced by opening the default, whether the opposing party elected not to raise the default issue until after the default, and whether the defaulting party acted promptly. Now, we assert to Your Honor that the facts of this case do present a proper case for opening the default. In her response, the plaintiff does not argue that she'd be prejudiced if the default were to be opened. Indeed, the default occurred almost a year ago, and the plaintiff waited a year before taking any action. The plaintiff also sued another party, which they ultimately dropped. To the contrary, and I think this is very important, to the contrary, and the reality is not only will my clients, but also the plaintiff be prejudiced if the default is not open because there will be no insurance coverage. We have attached, as part of Mr. Borak's affidavit, an email from claims counsel, in-house claims counsel at Travelers, which confirms the defendant's representations that there is currently no insurance coverage for plaintiff's claims because of this default. But that if the default is open, Travelers will provide a defense, and that Travelers is not, quote, currently aware of any facts which would eliminate its duty to pay for any verdict under the policy limits levied against Hale and Jowls in the event a verdict is rendered, close quote.
All right. So, Mr. Christie, I actually, because this is kind of unique in the sense that the unique part of this is that you all assert that you gave it to the person who's responsible for initiating the information with the insurance company. That person acknowledges that they received it but didn't do what they were supposed to do. So that's a unique twist on this. But essentially, the default's a default. So on behalf of the plaintiffs, why isn't this a consent since the win is that you get insurance coverage in this case as opposed to an empty default judgment?
Well, Your Honor, I don't think the question of or the issue of insurance should really factor in here because
it doesn't really, but
there's solvent defendants who have hired counsel.
But usually in cases like this where you know that the tendency for a court, especially one where discretion is in place and where the rule tends to be open default so that these cases can be decided on the merit versus the draconian penalty of maintaining a default when excusable neglect and proper case and all of those things can be shown. So tell me what's the downside to me opening default?
Well, Your Honor, passage of time, and I don't believe that the defendants have met their burden of showing excusable neglect here, that merely just forwarding it on to the insurance broker. And I admittedly have just started reading their response they filed today to our brief that attaches the affidavits from Mr. Borak and the information from Travelers Claims Counsel. But the original motion to open default, which was filed essentially a month after default was entered and on the eve of Your Honor previously having set a hearing, That's not what those actions aren't the actions of a reasonable property owner or property manager. The email where it's forwarded ends with, please advise the next steps. A reasonable property owner or property manager would follow up when there was no advice about the next steps. The next layer to that is Mr. Santos and Jollis, the property owner, was served later. And he, in his affidavit, I believe, states that he contacted Hale, and Hale said, our insurance broker is handling it. At that point, a reasonable person would have followed up. Someone else has called me. Let's make sure this is being handled. It wasn't. So there we would say that there is not excusable neglect. The cases we've cited, I think this is comparable to Flournoy as well as LSV 5-Star Dodge, which is 242 Georgia Appellate 474. And then on the proper case grounds, the issue is they didn't act promptly to open the default after they learned that no answer had been filed or timely filed. They waited essentially a month to file their motion to open default, which had some serious issues in it that they didn't attach the affidavit of Mr. Borak. It was just a self-serving affidavit from Mr. Hale and Mr. Santos, and then waited another month essentially to try to cure those deficiencies. We would suggest to the court that that's not evidence of someone who is acting promptly when they learned that an answer hasn't been timely filed. So we would ask that the court deny the defendant's motion.
Okay. All right. Anything else?
Your Honor, I would just say that we cited the case in our supplemental brief saying that 30 days is found to be reasonable. The motion was filed in less than 30 days after the Hale parties found out about the court's order. So I would suggest to the court that we have made out a proper case for a proper case and that the court in its discretion should set aside the default and avoid the loss of insurance coverage and also probably would ultimately be a bankruptcy, because given the seriousness of the case, if there is liability and if the meritorious defenses are not successful, then there could be a catastrophic verdict in this case.
And Your Honor,
Okay.
one last thing.
Yeah, I'm not going to argue the motions of the merits of the, tort reform. I think you've made a proper case. Go ahead and get me an order to open default. Make it simple.
Very well. I'll do that. I'll circulate it to Mr. Brown before submitting it to the court.
All right. And then, I think that in light of the new tort statutes, y'all, it may be, I'm going to see if what happens is more of a collaborative thing where, parties kind of try and get together on things as opposed to letting it play out, because it looks like the way it is going to establish itself with the bifurcated, trifurcated trials, it could be a lot more expensive in the long run. And so it's going to be interesting to us judges to see how this all works out. So it may just engender more collaboration between the parties.
Judge, this is Michael Rafey. I'm on a leave of absence, so forgive me for not appearing on camera. I did just want to mention that there's a very real issue on the insurance side that the defendant gave late notice to their insurance carrier. So this whole idea, I just wanted to at least mention that the idea
Are
that—
you representing the insurance company?
No, I represent the plaintiff, and
okay, but if they're saying that they have assertions in writing from the insurance company that if default is open, then and the coverage will be provided, which I don't see why that would be something that we would challenge.
Because that's not my understanding of what the statement is. The statement from the insurance company is, we don't, and this was just filed today, and I'm on a leave, and we're trying our best here, filed I think an hour ago. But the statement is that there's a caveat for late notice. So I do want to at least mention that the insurance company can very well say they had late notice, which if they didn't have notice until recently, which is what the evidence seems to suggest, given the insurance company did not respond, did not hire a lawyer, there's going to be a late notice deck action, and the prejudice to the plaintiff is going to be severe because they're going to have to go out and hire lawyers to handle that case. They're going to have this case. We've waited a year now to try to cure default. So the prejudice will be extreme. And I would just suggest that a reasonable and proper party does not hand a lawsuit to someone who has no legal training or obligation to do anything and then doesn't follow up for a year. So I think if this
Mr. Rafi, I've been doing these civil cases since I was on magistrate court. The civil cases with small business owners, with business owners, medium to large business owners, but with people who are business owners as opposed to lawyers. And the argument you just made is a lawyer argument. It's not a business person argument, because business people think that if they hand it off to the person who's supposed to do it and they're running their business, trust me, over the many years of argument I've heard with respect to something like this, your argument is more of a lawyers would do the follow-up, the due diligence, the staying on them because we know the timing issues. Business people, oh man, the stories I could tell. So I get from the standpoint that you're saying that there was a lack of diligence because he handed it off to somebody and didn't check. But I think that that's something we do as attorneys, and we're trained to do it. Not everybody does that, and business people aren't trained in the same way that we are. So with that respect, I just, this is just a different way to look at that argument. All right, but like I said, send me the order. I'll look at it all. If I decide I want to change it, I will. And then you all will get my order. But the law has not changed in this respect, that it favors cases being resolved on the merits unless something really egregious has happened.
Thank you, Your Honor.
Thank you, Your Honor. May we excuse?
Yes, thank you.
Judge, have a good day.
You too. All right, and the last case I think that we have is Moore, Trejo, Jimenez, Alvarado, John, Future Management, Delta Star. All right. And, Mr. Santos, I think if you are with the last case, you're free to go too, unless you want to watch, that's fine. So just hold on just 1 second. I just need about 5 minutes. All right, my apologies. We're ready?
Yes,
Yes,
Your
ma'am.
Honor.
Yes.
Judge, my name is Heath Brooks. My co-counsel is Will League. Other co-counsel is J.L. King. And we filed this amended motion to join parties just as a little bit of a background. This does involve a tragic wreck involving the estate of our client, Stephanie Laura Mendoza, and the defendant who is Future Management. This occurred in October of 2023. And we filed a lawsuit in November of 2023. We brought action against initially the driver of the commercial vehicle, Mr. Gene, the company he worked for, Future Management, and it was doing business as Phoenix Wholesale, along with the insurance carrier and another defendant who actually owned the trucks. After that occurred, sometime in March or April of 2024, the Future Management Corporation doing business as Phoenix Wholesale was sold to one of the defendants we're seeking to introduce now into the action, and that is What Chef Wants, who's Dixie Produce. And we have attempted to get some information from Dixie Produce, which I think will be important as part of our argument. And we've run into some roadblocks there. And also in the sale of the company, some of the documents that we have needed are tied up in an 18-wheeler somewhere, and we may have to address those issues in another motion down the road. But in any event, yeah, I get it. We may
So
have to,
you mean the data set that an 18-wheeler would have collected while it was on the road?
some of the paperwork, some of the information deals with some of the safety. But in any event, for purposes of our motion today, what we ended up doing is we ended up entering into some discovery. We ended up exchanging some paper discovery. We ended up taking a bunch of depositions, and following all of the depositions and the paper discovery,
with the current defendant.
Yes, ma'am. Yes, Judge. With the current defendants, there was some new information that was gathered where we thought it appropriate to add some additional defendants to the initial action. Namely, defendants are Mr. David Collins, who.
Okay, why are we adding David Collins? Why would we add?
Well, Mr. Collins, after the deposition of Mr. Collins, what we learned is that Mr. Collins was in charge of supervising the driver of the actual truck, ensuring that he, along with another defendant, ensuring that the driver of the vehicle maintained safety regulations while he was operating the truck.
But as an individual, wouldn't he be under respondeat superior to the company that he was working for?
Yes, ma'am. He would, in addition to being responsible in his own individual capacity under Georgia law, which is very clear. Under Georgia law, you are responsible as an individual, and you can be responsible as an employee of a company. And in this kind of scenario, we believe as an individual, he's also responsible for his own conduct. And we've addressed that in our brief. And you are always responsible in Georgia for your own conduct. But in any event, the second defendant we sought to introduce is Cornerstone. And when Mr. Gene, who was the driver of the vehicle, when Mr. Gene was driving his truck, there was a passenger in this commercial vehicle. His name was Cesar Ruiz, and he was working for a company called Cornerstone. And prior to the wreck, and go ahead and tell you, I didn't get to tell you initially, the reason why this wreck occurred is because the driver of the Future Management truck fell asleep at the wheel. And we actually have that on video. And one of the things we also have on video is not only was the driver asleep, but his passenger was asleep. And one of the things we believe we will be able to elicit through our expert testimony and also through applicable safety regulations is that as a passenger in a commercial vehicle, you are not allowed to be asleep while that vehicle is in operation. And the reason for that is because when you fall asleep, it results in the driver falling asleep, or could contribute to the driver falling asleep as well. So both of these individuals were not alert, and that's what caused this collision. And we believe we can introduce that testimony and introduce that evidence. The third individual or company that we seek to introduce is a company called LMSC. And that company was an independent consultant that was providing all of the safety consultation work for the defendant Future Management. And the reason why that's important is because they were an individual company, and through various deponents and through various testimony that we've been able to gain, LMSC was responsible for providing all the training to the driver, James Lee Jean. They were
And would have employed Collins?
I'm sorry?
Did LMSC employ Collins?
No, ma'am. They were their
Okay.
own consulting company that was hired by Future Management for safety consulting purposes. And in fact, in the corporate representative deposition, which we were able to obtain, which we did attach to our motion, the company admits that LMSC was responsible for the safety consulting of the entirety of the company. So they are clearly individually responsible for for failing to properly train Mr. Jean. The fourth company that we sought to introduce, or defendant we sought to introduce, is the actual successor liability company. And that is what Chefs want. They actually bought Phoenix Wholesale. And we did elicit testimony from multiple witnesses that many, if not all, of the employees that were hired to work for Phoenix Wholesale were also offered a position with what Chefs want, and many of them moved directly over to what Chefs want. So we believe that through the discovery process, we will be able to develop the testimony necessary to show that they are just a continuation of Phoenix Wholesale. Plus, the other important point is that Phoenix Wholesale or Future Management divested themselves of all their assets to what Chefs want after the filing of this lawsuit, which we believe will be another important point as we move through this litigation process.
Except they got the money for the sale.
That's right.
So
well, we haven't been able to get the discovery from what Chefs want and or from Future Management regarding that sale. So once we are able to get that testimony, and once we are able to get that discovery, then we believe we can make that showing. But at this point, it's not necessary for us to have an evidentiary showing. We are merely asking under 911-19 and 911-20, which would be necessary joinder or permissive joinder, to allow these defendants for the court to allow these defendants into the case, because without an evidentiary showing, they're all part of the same occurrence, transaction, and series of events, and they're all defendants. We believe we could overcome a 12B6 motion on these issues. But at this point in time, that's not necessary to even address. And we're within the statute of limitations. So presumably we could file individual actions against every one of these defendants and then seek a motion to consolidate, so that we would all, for judicial economy, want to try these at the same time. At the end of the day, they are all individually responsible for their own conduct and for contributing to the death of Miss Laura Mendoza. And we believe the evidence will show that, should the court allow.
All right. Response?
Thank you, Your Honor. Mark Bardak, Freeman Mathis, and Gary for all of the defendants. So, Your Honor, their plaintiff's motion fails because none of the parties, and you've kind of hit on this, none of the parties that they want to add owed any duty to this decedent. So a couple of things to just give some context. This accident involved a box truck that was driven by defendant James Lee Jean. It is undisputed in this case, Judge, that he was employed by Future Management, which is also known as Phoenix Wholesale, and only by Future Management, and not by any of these other people, individuals, or entities that plaintiffs want to add. At the time of the accident, he was driving this box truck under Future Management's DOT number for Future Management. He was making deliveries. Future Management, Judge, just so you know, and you probably have seen their trucks. No, they provide produce to like Moe's, McAllister's.
Okay.
You've probably seen their gray trucks that say Phoenix Wholesale with the Phoenix logo.
Yeah.
If you've been to Shane's or Moe's or McAllister's or any of those, you've probably seen one of their trucks parked out by him. So that's what he was doing. And he's got this passenger, Cesar Ruiz, and for whatever reason.
So is Cesar Ruiz hitching a ride, or is he a driver?
No.
Or what's his role?
Yeah, that's what I was going to explain to you. So he, again, a little more context. He actually came to Future Management through a staffing agency. That's Cornerstone. And he's basically a driver's helper. So his job is when they get to Moe's or McAllister's or wherever, if it's a bigger load, he helps unload that stuff. Okay. So why don't we start with him? So he, again, owes no duties. The plaintiffs say in their brief that they contend Cornerstone never provided any training to Ruiz requiring him to remain awake, and there is ample evidence Ruiz, in falling asleep, violated safety rules and or regulations regarding the operation of commercial vehicles. And you just heard Mr. Brooks say, "Oh, we're going to show these regulations." There aren't any, Judge. There is nothing in the law, any requirements, rules, regulations in the FMCSR or anywhere else, at least that I'm aware of or that I have found, requiring a passenger to stay awake. And so they are asked.
The question, I guess what occurred to me was tandem drivers.
It's not a tandem.
Yeah.
It's not a tandem driver situation. And even then, if you think about it, Judge, I represent a lot of trucking.
I thought they were like, and I don't know everything about the over the road trucking, but I thought the whole point of having a tandem driving situation is that one rests while the other.
That's exactly what I was going to say to you. Yeah, no, you're exactly right. You're exactly right. But this isn't even that situation. They're not on a tractor trailer. They're in a box truck. This guy's along to help. He's not a driver. He's along to unload stuff when they get there. And so basically what they're asking you to do as far as Cornerstone goes is to create a whole new theory of liability that a passenger in a vehicle can be liable to another driver on the road. And that just is not the law in Georgia. So Cornerstone should not be added. And let me just backtrack a little bit and say, to be added, plaintiffs need to show that these are indispensable or necessary parties. And so if there's no theory of liability against them, someone doesn't owe a duty to the plaintiff, or in this case, the plaintiff's decedent, then they can't be a necessary or indispensable party and shouldn't be added. So now we come to Dave Collins, who's the owner, CEO, chief bottle washer of Future Management. And again, and as you hit on, Judge, during plaintiff's presentation, is he's doing all of this in his capacity for Future Management. He did not individually employ Mr. Gene. He did not individually own that truck. He did not individually put a driver or a vehicle on the roadway. So there's no duty that he individually owed to the decedent either. Anything that he's done is in the context of him doing that on behalf of the company. And one of the things to consider in adding a party, is there another remedy? The remedy here is to sue Future Management for either vicarious liability and or independent negligence, negligent training, hiring, supervision, whatever, which they've done here. And so, again, they're trying to create a cause of action or theory of liability that doesn't exist. If you do what they're asking you to do, Judge, that is opening up for, in every single case where a corporation is sued, for the CEO to be named individually. And that's the whole reason not the whole reason, but it is a major reason why we have corporations. So Mr. Collins is entitled to that protection. And again, nothing that he didn't do anything individually. So that takes us to LMSC. LMSC is, as Mr. Brooks correctly stated, was a consulting company that Future Management used basically as their safety department, to do hiring, training. What they did not allude to is basically LMSC would make recommendations, still ultimately the company's responsibility. And similar to what I just said about Mr. Collins, LMSC may have owed duties to Future Management, but they didn't owe any duties to the decedent in this case. LMSC did not employ Mr. Jean. LMSC did not own the truck. So LMSC did not put a driver or a vehicle out on the roadway. Yeah, it would be akin, I don't know if you're familiar, Judge, with J.J. Kelleher. They provide a lot of training materials in the trucking industry. They're sort of like the leading company that provides, training materials and videos and all that kind of stuff. And a lot of trucking companies use those materials as part of their training. Or if you're familiar, these are the two examples I thought, if you're familiar with SafeServe, which trains bartenders, right?
Mhm.
So what the plaintiffs are doing is akin to saying, hey, in a dram shop case, you get to bring in SafeServe because they train the bartender. Or you get to bring in, in this suit against a trucking company, you get to bring in J.J. Kelleher because we think their materials were deficient. Again, those entities may owe a duty to the company that hires them, and the company that hired, like in this case, if we really felt like LMSC, didn't properly train, we might have a third party complaint against them, but the plaintiff doesn't have a claim against them.
Mr. Bardak, let me ask you.
Yes, ma'am.
I know this might seem simplistic, but so my understanding is there's video, right?
Yes, ma'am.
Okay. Is there anything other than the driver fell asleep?
No, ma'am.
That would have
No, ma'am.
been or is
No, ma'am.
alleged the cause of this?
No. Let me say it this way. We have inward and outward facing dash cam on this truck, and the inward facing dash cam, it looks like he's doing some head nods, and it looks like he falls asleep. The passenger's asleep, and he unfortunately runs into the back of the decedent's vehicle and drives her off the roadway, and she's killed as a result. That's it. Now, I think plaintiffs are going to say, well, they're putting this tired guy on the road and they should have known he would be tired and all this stuff. But yes, that is what this case is about, is that we had a driver fall asleep at the wheel and run into the back of this woman. And that's what this case is.
Right. And then the last, I guess
so what chefs want are Dixie products. So again, a little more, kind of like I don't know if you remember Paul Harvey, Judge. Now the rest of the story.
Paul Harvey. The rest of the story.
So what happened here, and I don't know if you're familiar with what chefs want. I think it's a Kentucky-based company. They do the same thing that Future Management did, frankly, on a bigger scale. Okay. And now where you saw all of those Phoenix wholesale gray trucks, you are now going to see red What Chef Wants trucks. I've seen them all over town already. Prior to this accident, and this is all in Mr. Collins's testimony, there were discussions about What Chefs Want buying Future Management. That sale happened after this accident, and it was asset purchase only agreement. And that agreement, with the numbers, the financial information redacted, has been provided to plaintiff's counsel. So they know what type of agreement this was. There's not any question about it.
And so with this being the sale being after the collision, all of that information about pending liability was contemplated in the sale, contemplated in the exchange of assets.
Well, I'm not quite sure how to answer that, Judge. In this sense,
I don't want to go too far afield. What I want to know was this, because a lot of times when people say, "Oh, they only bought assets, they didn't buy liabilities," but this was known to them as a part of when the sale was transacted.
Let me say this, and again, I'm not 100% certain about this. My understanding is that, and I know certainly now, What Chefs Want was aware of this accident. But to your point, they did not buy any liabilities. They bought only assets. So they bought accounts and they bought trucks. They actually bought the trucks from Delta Star because that's who owned the trucks and then leased them to Future Management. So, and then they went through, and as Mr. Brooks said, you know, they offered a lot of people, not everybody, but they offered a lot of people positions with the purchasing company. Because Future Management's not going to exist anymore. I mean, they're winding down. But to show successor liability, Judge, you have to show common ownership and basically a continuation. There is not common ownership here. There's not even one common owner. You know, in other words, this isn't like, okay, Mr. Collins and some other people created a new company that bought this. This is a wholly separate company that purchased the assets of Future Management and Delta Star. Actually, there were two companies that purchased the assets, primarily What Chefs Want. There was another company called Murano, something like that, that was sort of a part of the deal as well and bought some of the assets. But we don't have common ownership at all. Mr. Collins has gone, as I'm sure you have seen a number of times, you know, when a business owner sells their business, they go to work for the new company, they're an employee, they get a salary, you know, they're basically getting paid for their goodwill, and all that. And which is exactly what Mr. Collins testified to here.
Future Management, the name ceases to exist, so there's no continuation
Yes, ma'am.
of the goodwill under Future Management.
That's correct. I mean, again, as I said, you'll look around now, you'll see all the What Chefs Want trucks, not Future Management. It's all been rebranded. They have a different location, so it's not even like they took over their building. They operate out of a different location, actually a couple different locations. But I think the main thing is, you know, there is not one single owner in common, let alone true common ownership. That would suggest or support in any way an argument for successor liability. And the fact that a bunch of employees who were at a company that now no longer exists has gone to a new company that does exist, that does not create successor liability. That's not Georgia law. And I would suggest respectfully, the plaintiff's counsel is completely ignoring Georgia law. So they know what the arrangement was. The law is clear on successor liability. It does not exist here. It cannot exist here because of that lack of common ownership. And again, so again, What Chefs Want or Dixie Products also owed no duty to the decedent. They weren't involved in this at the time of this accident, other than having some discussions with the Collinses. So again, there's no basis to bring them in. They are not an indispensable party. So plaintiff's motion should be denied in its entirety.
All right. Anything else?
Yes, Your Honor. A couple of things for the rest of the story. The first thing is with What Chef Wants, I think I appreciate Mr. Bardock and the information that he's provided, but he's providing testimony that's really just not facts in the evidence. But he is not aware of what Chef Wants knew, or their awareness of this tragic accident, I think plays a whole bunch into the information we need to gather through the discovery process and taking a corporate representative deposition and finding out how this sale took place, which we're entitled to do at this point in the litigation, because we're not making an evidentiary showing here. We're saying, hey,
I get it, Mr. Brooks, but so that this doesn't sound like what you're doing is just trying to pull everybody in until you can weed everybody out.
Right.
Let me ask you this. Would you be able to gather the information, particularly any information that would be germane to the collision and future what is it called again?
Future management.
Doing business.
I wanted to say future market. Future management, any information that would have been germane to the collision from the What Chefs Wants through third-party discovery, opposed to pulling them in to defend litigation that it seems the connection is very attenuated.
And here's the thing is that I don't know the answer to that question, because we did send out third-party interrogatories and requests for production to What Chef Wants. I followed up with letters. We didn't receive any information back from them aside from Mr. Barlick is right, the initial contract that was executed after after our lawsuit and after our collision. So I don't know the answer to that question. We haven't received any information, but I think we should be afforded the opportunity to take some depositions to find out where those documents are, who has them, and what information they can provide to us as a company, particularly at this point in the litigation where we don't have to make those kinds of evidentiary showings now. But we think we have enough information that we could move forward. In terms of LMSC Incorporated, one of the real salient points in this case is going to be that there were multiple violations of hours of service of Mr. Jean that we believe ultimately resulted in him falling asleep behind the wheel. We are going to have expert testimony that they violated. Mr. Jean was in violation many, many times of his hours of service requirements. I think 30. One of the things that LMSC admits to being responsible for is signing in and signing out their drivers, along with ensuring that they follow regulations and they were following the Department of Motor Vehicle Safety hours of service. That is an independent responsibility, and that is a duty to the community, inclusive of Stephanie Laura Mendoza. You have an independent responsibility in the state of Georgia to ensure that you're doing what you're supposed to do, particularly when it is ensuring commercial vehicle drivers are safe on the roadways. And these guys did not do what they were supposed to do, and they breached their duty. And now Miss Laura Mendoza is no longer here, and she's got 4 kids that have lost her. In terms of Cornerstone, I appreciate Mark's assertions that he doesn't know of any laws and he doesn't know that Mr. Ruiz falling asleep violated any safety rules. That's for the experts to determine when we try this case in front of a jury, or for expert testimony to be elicited that yes, when you are a passenger in a commercial vehicle, you are not allowed to fall asleep. And when you do that, the reason
is that something under the Federal Department of Transportation rules, or is that a statute somewhere? Because I mean, you can say that is a custom of the industry. You can, but I got to know where that comes from, because you're telling me that that's what pulls this gentleman. That very fact pulls this gentleman into the litigation, and by pulling him in, it then pulls in his company, the staffing company that placed him in the truck. So is there a federal rule somewhere, or a DOT rule, or even a Georgia statute that says if you're the passenger in a commercial vehicle and that vehicle is operating on the roads to do the commercial purpose for which it's been initiated, you cannot, as a passenger, because I'm gonna tell you, if I was just the driver's helper and I gotta wait until we get to a stop before I have to do anything, I'd be knocked out the whole time. Because moving vehicle, I go to sleep. So tell me what tells me that I can't.
Because you're a commercial vehicle, and I believe we will be able to elicit expert testimony that is a breach of a safety regulation.
Testimony has to be based on something. And what I'm asking is, where's the rule that an expert would review to give testimony under a Daubert standard that says this is a rule, a hard and fast rule in either under the federal DOT that manages commercial vehicles?
That in our consultation with our experts, that's what we believe the testimony is going to show. We don't have that discovery yet. We are just to the point where we're trying to add this defendant because we elicited testimony from him of who he actually worked for, and the fact that he was not properly trained by Cornerstone in ensuring what his job was supposed to be. It could be in Cornerstone's policies and procedures. At this state of the litigation, without having the discovery necessary, and in consultation with our own experts, we believe we will be able to elicit testimony that not only creates the duty, but shows that Cesar Ruiz breached the duty and Cornerstone failed to properly train him in following his duty. And because of that breach of duty, it resulted in an increased likelihood that the driver of that commercial vehicle would he himself fall asleep as well. That's what the testimony we believe we're going to be able to elicit is. But at this stage of the litigation, in a permissive joinder situation, and I appreciate Mark reliance upon necessary joinder, but there's a couple of other statutes that we can rely upon that permissive joinder being one of them, and also just Rule 15 under Georgia rule in terms of adding parties. But we believe we could get the information necessary to overcome not only a 12B6 motion, but a motion for summary judgment. And then the last individual is Mr. Collins. And the reason why Mr. Jean is in this case is because Mr. Jean is the driver of the truck. He has an independent responsibility to every driver on Georgia's road to not fall asleep and kill someone. Likewise, Mr. Collins, as an individual working for a company, has a responsibility to ensure those drivers are all trained, as he says his responsibilities are. Under the theory that only people the only time people are responsible when they're working for a company means the company is responsible, would take out everybody's individual responsibility in Georgia. And as the case law is clear, under Georgia law, Collins is personally an individual defendant is personally and independently responsible for their own conduct. That's the Pazar case, 659 SE 2D, but I could cite several other cases that follow that same line of reasoning. A defendant in the state of Georgia, when they have wrongful conduct, is responsible for their own conduct. You are responsible for what you do wrong and the duties that you have to everybody else out there. And we think we have that information to show that Mr. Collins breached it when he failed to properly train his people. JL?
I had a few things to say, but Heath, I think, covered all of those. I just would like to point out to the court, though, that what we're looking at here, we got statute of limitations that runs in October. We believe that we have viable claims against all these entities that we're seeking to add. And we're going to feel like our duty to our client is, because obviously, whatever the court rules here can't be collateral estoppel because those parties aren't even here, is if the court doesn't allow us to bring it in, our option is going to be to file another lawsuit with all these parties. We're going to have a litigation mess as far as all parties involved in two separate lawsuits, a consolidation, and it's going to get messy. And I understand Mr. Bardak has a lot of arguments, but those arguments need to be made by counsel for those parties who know that information and whatever they have to have. And we need to get everybody together. And like we said, we believe we can beat summary judgment on all of these with the facts that are already in discovery right now. We wouldn't be bringing that. We looked at multiple other parties. The court can see that we amended our motion. We filed an original motion to add parties. We amended it. In that amended motion, we took a party out because we got more discovery that showed that, hey, we're not likely to beat summary judgment as to that party that was in that first motion. And we're trying to get the right parties in the case and to do this as efficiently as possible. And we think this is the way that we can be efficient in doing that. And that, hey, if everybody agreed, we wouldn't be here. But we think the best way to handle this whole matter and to get this tragic situation resolved is get all these parties in, let their lawyers get in, they make their arguments, we make our arguments, and you get to be along with the jury to figure it out for us. And I think getting all in one place at one spot before everybody is the best way to handle this to get efficient justice for all parties.
So I have one more question. So the argument has been made that LMSC, on one side, it is sort of like, I don't know if y'all are familiar with NHTSA, the National Highway Transportation.
Sure.
Yeah. So NHTSA does the training for how do you evaluate someone who may be an impaired driver. And they promulgate the manuals, they teach the classes, they train the trainers. And so once they've done that, then it's incumbent upon the trainers or the individual law enforcement agencies to then, train in the way that NHTSA would have you to do it so that it is standardized. Now, LMSC, the argument is being made on behalf of the defendants that it is one of those standardized kind of entities where they have a standardized method of safety rules and regulations and things that are best practices in the industry.
Judge, Judge, I'm sorry to interrupt you, but I want to be careful because I don't think that's.
If I didn't make it the argument the way that you would, I want to be clear on what you're saying.
If I may, I'd like to address that as well.
Well, I'm going to give you the chance because I'm coming to a question, but I want to make sure I'm understanding.
Yeah.
Their argument.
My understanding the question was.
Okay, wait, I was speaking and I would like to.
I'm sorry, Mr. Burdock. Go ahead. But if the question was to Mr. Burdock, if it was to us, Your Honor, we would like.
Okay, I get it. Let me understand from Mr. Burdock's point of view, and then I have a question for you.
Thank you, Judge. I just want to be clear. LMSC is not like NHTSA or even JJK. I mean, this was like their only, and they did some other work with food safety stuff as well. But in terms of transportation, this was like their only client. So I don't want you to be under the impression that this is a, regional or national training company that has.
Okay, good, because that's where I was thinking.
Yeah, and I want to be clear that they're not. But again, I think the overriding point is for them as well as all of these other people, and this is, I think, the piece that plaintiffs are either missing or ignoring, is that you cannot be liable for negligent training, negligent hiring, negligent supervision of someone that you don't employ. And none of these entities or individuals employed Mr. Jean. And that should end the discussion right there.
Okay. So thank you for clearing that up, because the question that I had is, the point was made that LMSC managed hours over service. And so is it that the company didn't keep track of those hours? They hired a contractor to manage whatever. So if I'm a driver and I'm putting in my, whatever electronic or digital information that I have to provide, or gets provided automatically when I sign in to drive, that information went to LMSC to manage my hours of driving. And this is kind of, it harkens back to when I was a kid. My dad was a B-52 navigator. And when we talked about crew rest, and I would, the navigator, the B-52 crews would go on security alerts, and they would be on the base for a while, but they couldn't go over their crew rest when it came to actually being up in the air. So this is what's coming back.
Sorry,
Judge,
to interrupt you, Mark, but Your Honor, you make an excellent point. Will League on behalf of the plaintiffs, Your Honor, and that's a good point. So the distinction of the dynamic of LMSC, Stuart Singleton, and we took Collins' deposition, over 1,200 pages of testimony, and Stuart Singleton, who is the head of LMSC, calls himself Captain Safety. The distinction and dynamic here, Your Honor, is that Stuart Singleton, on behalf of LMSC, interviews the drivers, fills out the paperwork with the drivers, trains the drivers, and also supervises the drivers. So in this case, we intend to show that there are several violations, as Mr. Brooks pointed out, of violating hours of service. So we got a poor kid from Haiti who they worked to death. And with the hours that they worked this kid, they're almost impossible for any human being to stay awake. But when it comes back to LMSC, Stuart Singleton, who we want to add, Your Honor, testified. They trained, met with, filled out documents, watched videos. But not only that, Your Honor, they signed off and reviewed all of the hours of service that this poor defendant who killed this lady, who had no way of staying awake. So they were intricately involved. And there's a contract between David Collins, future management, to hire, train, and supervise these employees. And they relied on LMSC, but Mr. Collins also testified that he was the guy who ran the show. And so both of their conduct ignored the federal DOT regulations of hours of service and failed to monitor, and they have a duty to monitor that. And Mr. Burdock points out there is no duty. Well, LMSC was contracted to provide safety for the company, which is the essence of this particular case. And so, so Collins, under the law Mr. Brooks cited, is both independently liable for his failure. LMSC, Stuart Singleton, we intend to bring them in for their particular violation when they were contracted and brought in. And by the way, Your Honor, LMSC's offices are within Future Management right down the hall. So it's kind of one, they had an independent contractor right in their, in Office C right down the hall. So they're commiserating, all the time. And so, and just to touch a little bit on Mr. Ruiz, he was, when you see the video, Mr. Ruiz is asleep, the Mr. Jeans is asleep. And with the expert testimony, we intend to elicit that is part and parcel of maintaining a safe environment in that vehicle. He's not only, and we have yet to see the policy procedures for Cornerstone that Mr. Ruiz worked at. And by the way, in the beginning of this litigation, I'm sorry, Your Honor, go ahead.
Is Cornerstone, i.e. Mr. Ruiz's connection to this case, dependent upon what the manual says for Cornerstone? So if there's nothing in it that says Mr. Ruiz's job is anything other than a driver, that he's not in any way part of the safety metric that the driver has, he's not the one who's supposed to keep the driver awake, or that is not part of his role. If what he's supposed to do is just when they get, his role essentially starts when they get on site. He's to get out of the truck, load and unload, make sure that he's loading properly, or maybe manage the logistics, knowing which cartons and which cases go to which business, while Mr. Jean's job is to get them there. And then when he gets there, his job starts on site. I'm gonna drop off 18 cartons of lettuce, 9 cartons of tomatoes.
Right.
And then when he gets back in the car, he essentially is on pause until they get to the next location. Or is your bringing Cornerstone into this lawsuit dependent upon Cornerstone actually saying in their manual that you cannot, most jobs tell you can't sleep on the job, but you cannot go to sleep. Part of your job function is to make sure that the driver operates safe.
Yes, 2 things, Your Honor. That's exactly right. It may say in their policy and procedures. Now we believe in the beginning of this litigation, they didn't know nobody knew who employed Mr. Ruiz. Okay, the policy and procedures may say. Now we know we believe he's paid by the hour, so he's being paid while he's in that truck, sleeping or whatever he's doing. With the testimony so far from the defendants is he's just there to help unload the heavy stuff. Our expert, and we believe the policy and procedure, but we don't know yet because frankly we've been stonewalled on the discovery, and that's okay. They got to do their job. I get it. But both of those theories and our expert testimony, we believe at a later juncture can prove that he does in fact have a duty to be part of that team, to be part of the safety environment within that truck, because we all get it. If I'm driving my kids to the beach or wherever we're going, if they fall asleep or it's a little bit, I feel like I'm a little bit sleepy myself when everybody else is asleep. But that's for the experts. And so we've got over 30 hours of 30 violations of hours of service. And if that's an issue in this case, we believe that further testimony is warranted to at least ferret out. If they didn't do anything, we'll let them out. But at this juncture of the case, Your Honor, the successor interest of what chefs want, David Collins' own admission as to he's the head guy, Singleton, LMSC's testimony that he, Mr. Curtis, ran the show along with LMSC. Mr. Singleton was there to meet with, fill out paperwork, train drivers, and monitor their hours of service. When we intend to show numerous violations of those hours of service, that brings all of them in, at least at this juncture. And later on in the case, if we can't find the evidence to link them in, then they get out on a summary judgment motion, or even
Mr. Brooks. I'm sorry, I get that.
Mr. Lee, that's fine. Or
Mr.
Will.
Lee.
Yes, ma'am.
But the issue is that you know, I just don't do these things willy-nilly. There is a cost with having to defend a lawsuit. And so while you say, oh, it's as simple as, you know, once we finish our fact-finding mission, they'll get out on summary judgment. Well, they're spending money to participate in the lawsuit, to participate in discovery, to request and possibly receive a summary judgment motion, money that they will not be compensated for. They won't get that back. That's just money that they're going to spend to defend. Is this the whole universe? Because my understanding is we're coming up on, what is it? You said October is the statute of limitations?
Yes, Your Honor, it is the whole universe.
Is this the whole universe of things I need to contemplate as to how much more we're going to expand this lawsuit?
Yeah,
and I get it. I'm not saying this in the sense of, oh my gosh, y'all are doing too much. There are a lot of parties in this lawsuit, so it's going to be a lot to manage. What I want to know is, are these all of the people prior to the statute of limitations that I need to contemplate coming as additional members of this lawsuit?
Yes, Your Honor. At this juncture, everything we found out so far.
It's the at this juncture part that gets me.
Yeah, yes, Your Honor. I can't, since we don't have our discovery, I can't honestly say that this is the entire universe. I believe that it is, based on everything we've got so far. We think it's successor interest, what chefs want, LMSC, Mr. Singleton, and Mr. Collins, along with the driver's helper that was in there with him. So yes, we believe those four are the entire universe, but I can't answer the court's question honestly, because again, we don't have all of our discovery. And I believe we have a motion to compel at a different date. And if we can exchange the discovery, and I think there was a miscommunication earlier. They sold the company, and the testimony from Mr. Collins is they took all the documents and they put them in an 18-wheeler truck bed of a truck somewhere, and they either can't get to them or having difficulty to get to them. And so I'm like, well, tell me where the 18-wheeler truck is. I'll go down there and look myself. But we, on behalf of these four kids, we got to find the documents and find out what chefs want knew, what they bought off on. We believe the testimony is going to show that they bought it knowing that there was a liability out there. They bought it for cheap, and they offered almost everybody employment. And we wanted to further.
That still doesn't mean that they continued the business. That just means that what chefs want saw a good opportunity to get a steal.
Your Honor,
right.
Your Honor, that's one of the elements of successful liability in Georgia. There's a few different ways you can get there. And in a situation where if Mr. Bardak's correct and you don't have the same ownership, if they sold significantly below the market value.
Because of the existence of the.
Yeah, then you can get there on successful liability. And that is, we have a concern that is the case here. And I think that.
Okay, so let me ask you this. Is this going to be a situation where we got to bring in somebody else for the purposes of valuation, or y'all going to do that with your experts? And that's not something I got to consider.
Once we get that information, then we'll be able to take a look and see if, we're our own experts. We'll be able to look at that and see what we've got and where that is. And I think that, you ask if this is the whole universe. I mean, the scenarios where this isn't a whole universe is if somebody comes in and we get later discovery that directly contradicts something we've already got. Like if we have a straight up, Mr. Collins said this in his deposition, but he's just wrong, then that might change things. But absent somebody completely contradicting the information we got, we think we've got the whole universe here. I mean, it'd take as lawyers, we never want to say never, but we've done a lot of discovery here, and we feel really good that we've gotten everybody. And that's sort of why we got to this point, because we did all the discovery we've done because we want to get everybody, and we want it to be clean as much as anybody does.
Okay. So I will be honest with you. We're going to be learning together because under the new tort reform rules, we're going to be doing it under that, and we're going to be learning as we go. So I haven't had to really do a lot with them yet. And we'll be managing it. But I get how much is at stake in this litigation. As in all litigation, everybody deserves the right to have discovery, the right to get to trial, the right to have the opportunity to have as much information as is necessary if they choose to settle the case or if they choose to go forward. And I get that there have been significant tragedies in this case. And so with that being said, I'm sensitive to all of those things, but as the judge, I balance factors on both sides. So the fact that, the plaintiffs have suffered a major tragedy doesn't mean that I don't also have to consider what bringing additional defendants into the case will cost them, particularly if it is defendants who are here just to figure out if they should be here. So with that being said, I will make those decisions. This argument has been helpful because you all have clarified, particularly with the role of some of the individuals, because I was thinking one thing and, once you've kind of put it in a context that it makes more sense to me, then it is clearer on where, on the evaluations that I'll need to make or to continue to make with respect to making this decision. So we will get an order to you.
Okay, Judge Matt.
Yes.
I'm sorry, just because I was triple teamed and had a few things thrown at me.
Mr. Broderick, you're at your best.
He's the best lawyer here.
Listen, I'll take. I don't have any problem taking them on. But there's a couple things that I would appreciate the opportunity to respond to, if nothing else, for the record.
No, that's fine.
And one of those things, for starters, is this notion of hours of service violations. The plaintiffs are looking at the wrong rules. They're applying the 10-hour rule that is applicable to long-haul drivers.
Okay.
This guy is operating within 150 miles, and coming back to the same place. So basically, he just can't drive. He just can't be on duty more than 16 hours, 2 days in a row, in a 7-day week, or for 7 days, and he's not, because he's got a day off every week. He never works 7 days, so there aren't any hours of service violations here. So that I want to get that on the record. That really doesn't have any bearing on your decisions today, but I don't want to let that go unresponded to. But a couple of things that I do think are important is, some of what you've just heard from these guys is, well, we want all this discovery. Well, there's nothing. This case has been going on for a year and a half. There's nothing that has prohibited or prohibits them from taking a deposition of what Chefs want as a non-party, of taking a deposition of Cornerstone as a non-party, of getting Cornerstone's policies if they think there's something in there that would create some liability. None of that's been done.
Please don't ignore the opportunity that if Cornerstone believes, or any of the entities believe, that they have information that is proprietary that they don't want to release, then I don't have a problem with documents being filed under seal, subject to you all having access to them. That is also a tool at our disposal.
And one of the issues is, and frankly, Judge, I think it's a little bit of a false pretense of, well, we want to know what this company was sold for and whether it was sold on the cheap. Again, what they're trying to get at, Judge, is their feeling is that my client didn't have enough insurance for this case, and they want to know what Mr. Collins got in his pocket, or what the company got in its pocket, and whether there's additional assets to go after. That's what this is really all about, Judge. But there is just no indication that this was anything other than an arm's length transaction. And to get into that kind of financial discovery pre-judgment is inappropriate. So, just to sort of wrap this up, messiness is not a reason to add parties. And you talked about expense, Judge. Not only is it an expense to all of these other parties that could be brought in, but it's an expense to my clients, who have to, go through all of this additional and, frankly, what I think is unnecessary discovery. It's a very simple case, as you kind of hit on. It's a rear-end accident with a death, and we've admitted that Mr. Jean's at fault for this. So
I've had 3 rear-end accidents that I would have considered simple cases that have gone to trial this year, and every one of them was expanded well beyond what I thought at the onset would happen. So I'm no longer using the term simple rear-end case. So.
Well, and I want to be careful because when you've got a death such as we have here.
No, I mean, I'm not making light.
There's nothing simple about that, and so I don't want to sound insensitive to it, but it's just inappropriate and it's an unnecessary expansion of this case. It would be one thing had they gotten, if they had gotten Cornerstone's policy and it said, you are not to fall asleep. It is your job to, make sure that the driver's awake. Different discussion, I think, right? But we just don't have any of that here. This, again, our experts are going to say we've been in this case a year and a half. I haven't seen they haven't identified the experts, but again, and more importantly, and as you hit on, Judge, there is not a statute or a rule or a regulation requiring a passenger of a commercial vehicle to stay awake. So again, and I just want to make sure I hit all my points. So, no, and again, from our starting point, no duty that any of these folks had to the decedent. That ends the discussion right there. And then on the successor liability, the lack of common ownership, in addition to those other things. But that's the driving force on successor liability law, and we don't have it here. So,
Your Honor,
in fact, the evidence is specifically to the contrary.
Your Honor, real brief, I'll name this tune in 30 seconds. I know every lawyer wants the last word, and you've been very patient with it. We appreciate that. I believe we are going to show numerous hours of service violations. And I get it. We've taken a lot of depositions, but Mr. Burdock wants us to take depositions without the appropriate documents. I get it. I want my opponent to come in without any weapons. I want him to come in naked, right? So under the discovery rules of Georgia, we are basically entitled to this information. And Your Honor made a good point. We're fine for the documents to be under seal. We'll enter into any agreement. We ain't going to use these. We won't provide them to anybody else just for this case, just for these 4 kids to find out, because we're talking about a whole other company, what chefs want, that may be responsible for safety. And so getting this discovery is indispensable for us to really vet and find out what they knew, when they knew it, what they did, and what they didn't do. And Your Honor, our only recourse after this, if Your Honor decides not to let some of these, is to file a separate lawsuit to then get that, and it will cost more expense. And we are, as Mr. King pointed out, we want to do it in the most judicial, economic way we possibly can. And I said 30 seconds. Maybe I took 40. So I'm sorry, Your Honor.
All right. Anybody else? Okay, I like for everybody to have a full hearing. I'll listen, and then I'm gonna go back and woodshed, as they say, and figure out what it is I need to do. And then we will get an order to you. And understand that each of the considerations will, it's not gonna be a blanket order. I may allow some, I may allow none, I may allow all of, so it is going to be an individual consideration of all 4 of the potential entities based on the arguments that have been made.
Your Honor, and I'm sorry that I think that we focused a lot of this hearing on things that would be more appropriate for motion for summary judgment or 12B6.
No, well, I get really essentially what I'm tasked with doing is determining whether these are necessary and proper parties. And that doesn't always have to do with some of the things that we've discussed, but some of the things that we've discussed have put into context the role that each of these parties have played in this scenario. So it is within the nexus of operating facts. Where is everybody stand? Why are we considering them? There are some things that have been argued that may be more appropriate for a 12B6 or a summary judgment motion, but it doesn't mean that I don't need to know them to have the contextual basis for making the decision about whether these are necessary parties for this litigation.
understand, and I do want to just make sure it's clear that we're this is under permissive joinder too, under 91120, where the court has discretion, and and that's simply that all persons may be joined in one action as defense if there is asserted against them jointly, severally, or in the alternative any right to relief in respect of arising out of the same transaction, occurrence, or series of transaction occurrence, and if any question of law or fact common to all of them will arise in action. That's OCGA 91120A, and I think we've squarely hit that with all 4 of these potential new defendants. And I understand that Mr. Bardak disagrees with us as to the merits of those claims, but it's if that all persons may be joined if there is asserted against them joint, several, or in the alternative any right to relief, and that's what we have asserted against them here, and that's where we are, and that's the statute we're at now. And we believe that we wouldn't be making this motion if we didn't believe we could also.
So you're saying that I
Yeah,
have discretion, but I need to do what you say to do.
I'm saying that you have discretion,
Because
but
that's what it sounds like. You're saying, well, Judge, based on this, you got discretion, but doggone it, you need to do what I'm saying, because otherwise, I don't know what you're going to do.
I said, what I'm saying, Judge, is you have the authority to do that, and I think we've met that burden. And I think that the proper context here is what's the most efficient way to handle this. And is that to add these parties here or to
But I
force us
also, listen, I may not agree that this is the most efficient way to handle it. And y'all may go ahead with what I don't take it as a threat. I take it as a notice that y'all may then file individual cases if that's what you feel. But then those individual cases will be considered based on the information given to me and the statutes that I have to consider. And so just the fact that there exists the possibility of you filing additional litigation is not something that I'm going to consider when making this decision. I'm going to make the decision based on whether I feel that these are parties without which this litigation cannot go forward fairly to both sides.
And I think that the court's decision should be based on how you believe the most efficient way to handle all of this is.
I get that, but I don't know that making a blunderbuss decision saying, well, let's bring everybody in to avoid the individual lawsuits is, while you may consider it efficient, it may not be efficient, because I'm tasked with making the best decision I need to make based on the law with what's in front of me. Those other lawsuits are right now, that's an idea that's out in the universe. That is not in front of me. And so I don't need to factor that into my consideration of whether these parties, these 4 parties, which I will consider individually per party, whether they are essential to this litigation in the posture as a defendant. They may be essential for third-party discovery. They may be essential in some other way to you as defendants, but I mean, as plaintiffs, but I don't know that you telling me, well, Judge, if you don't make the decision we want you to make, we're going to file other lawsuits, is something that I need to consider to bolster my decision to rule in your favor. I don't see it that way. I see it as I take what is in front of me, I apply the law and my common sense and make the ruling. If I have to use discretion, I'm going to make the ruling that is best within my discretion, within my understanding of the law. And then whatever comes next, and I deal with that then. So y'all will find that I don't, and if y'all have looked, because most people will, research the judge that they're in front of or going to be in front of. And most people will tell you I'm not what they call an activist judge. I think that you all are professionals. I did civil litigation before I took the bench. And so I understand how it works. And so I allow you all to do what you need to do. I don't direct the litigation. I address what's in front of me to the best of my ability. but I don't direct litigation and I don't try and, pin it. I've heard of judges who are like, well, we're going to sit down and have a settlement, or we're going to talk about, I don't do that. That's not my job. My job is to make sure I'm making the best legal decision with what is in front of me, not to consider what might happen if I make a certain legal decision, as long as I believe it to be the right decision under the law and under my discretion. Now, if you check my appellate record, I think I've done pretty well over the 9 years that I've been on state court. I've been affirmed as a Superior Court judge sitting by designation, a state court judge, and a magistrate court judge. So I feel like if they're going to tell me no, I don't have a problem with that, but I'm going to make the best decision I know how to make.
And Judge, I understand where, and I think you perfectly described what you were looking at as to who to add based on 9/11/19. I think you described exactly what you should do under 9/11/19 as to necessary and proper parties. I think that under 9/11/20, the proper analysis is what is not necessarily, maybe they are necessary and proper, maybe they're not. I'm not at that point yet, but what do I think is the judge the most efficient way to handle it? And you may think the most efficient way to handle it is separate lawsuits. And if you do, then that's why you have discretion and you are the judge, and you may be right about that. It may be that you think the most efficient way is one, but that's where you have discretion on that. If you think that there's a party that's not necessary and proper, then I think you get to 9/11/20, and it's what do you as a judge believe is the most efficient way to handle it? And that's your call on that. That's where you have discretion. I don't think that you get to make that call, but I think what we would, in the event you'd have concluded that one or more of the four parties wasn't necessary and proper, we think the next prong should be what's the most efficient way to handle claims with that party. And if you think it's most efficient in another lawsuit, then we understand that that's what your belief would be there. If you think it's most efficient in this one, we understand that. And
you're saying, okay, it's most efficient to bring everybody in because we believe that we have the claims that we can maintain against these other entities. What I'm saying to you is efficiency. As I'm looking at it, if I'm looking at the parties, each of these four individual parties that you want to add, and I say from a standpoint of efficiency, I don't believe that you can maintain these actions that you want to maintain, because what you're actually looking for is you're trying to get discovery by way of adding someone to a lawsuit. And I don't know that that's the most efficient method when you have third-party discovery available to you. And you could use the third-party discovery to determine which of these four parties, if any, are necessary parties, and then bring the motion to add. But what you're saying to me is I should just add everybody and let y'all sort it out through party discovery. And then if some of these individuals through the course of discovery aren't necessary parties, then, we'll go through the motions of summary judgment and 12b-6. Well, what if it's less efficient to have to do all that than for me to say, yeah, use third-party discovery and get what you need, and then tell me that you want to add someone?
Well, Judge, I think if I can for just a second, I think the first three parties that we have, with what Chef wants, we think we're entitled to discovery. And I think in our brief, it's pretty clear where we say, hey, look, with what Chef wants and the accessory and liability, we do need additional discovery to make a determination about how we're going to move forward. We think through the discovery process, we would have enough information to amend the complaint to add them, but we do need some additional discovery with what Chef wants. In terms of the other three parties, Collins, who we have 1,200 pages of testimony on, LMSC, who we've taken the only employee of LMSC, and then Cornerstone, we have developed our theories through their testimony alone without the need for additional discovery. We're not looking for additional discovery to approve our claims in those cases with those three entities. Collins, LMSC, and Cornerstone, we believe we have enough information. That's why we included them in the complaint. I mean, we with Cornerstone, and I think we addressed this in our brief.
Okay, well, what's to say that I don't make that same determination? What I'm saying is, I
just wanted to clear
the
it up.
opportunity. I got you, but what I'm saying is, give me the opportunity to look at each of them, because the argument of efficiency, it doesn't. I don't see it the same way that Mr. King sees it. He's saying it's more efficient to add everybody now and sort them out later. I say, I don't think that's the most efficient way. I mean, if they don't belong and if you can't make a connection to them at this point, then we adding them for what? And at that point, if you decide that you've developed enough to add them as a part later and we do it through joinder, that might be a more efficient method than putting everybody in and then having to go through a 12B6 or a summary judgment motion.
Right.
So,
And Your Honor, I understand what you're saying, Your Honor, and I think that I was speaking generally. I echo Mr. Brooks. In this case, I believe right now we have evidence to defeat a motion for summary judgment as to LMSC, Curtis David Collins, and Cornerstone. With what Chefs wants, that's the one where you get to the permissive joinder and not 1120 that we really are going to. I think that one is, we got to have more discovery, and there's a chance that the discovery that we get there, which we've been stonewalled on. That's why we're here. So if they just give us the discovery, we'd say either, hey, we're there, we're not, but we've been stonewalled on that, and we're trying to move it along and, put the onus on them to give us this stuff and quit fighting us about it, because of their current defense is, you can't prove this. And by the way, you want Mr. Bardak saying you can't prove this against them, but by the way, I'm not going to give you the information that would allow you to prove it one way or the other. And that is a frustrating position.
I'm facing a motion for joinder as opposed to a motion to compel. So, I mean, I don't tell people how to litigate. I just deal with what's in front of me. So I will deal with this and we will move forward. And at some point, you all can expect a scheduling order so that we can, once we make sure we have all our parties in a row, we can get our ducks in a row and be prepared for the eventual trial of this case.
Thank you, Judge.
Great.
Thank you, Judge.
Thank you, Judge.
But I look forward to seeing you guys. Y'all are good argument, a good energy. I like it.
Thank you, Judge.
Well, thank you, Judge. Thank you for putting up with us and being patient with us today. And
every once in a while, a judge likes to exercise their law school chops.
So, you've done a good job.
All right. Take care, everybody.
Bye, Mark.
Thank you, Judge. See y'all later. Hey, JL. Oh, sorry.
Oh, Ms. Rodriguez, were you here for a particular thing? Are you court reporter? What are you doing?
She's
you gotta
positioned
unmute for me.
On the calendar, Judge.
I'm sorry.
She's position 5 on the calendar. I was going back through. I don't think we called that one.
I may not have. I'm sorry. Thank you for your patience, ma'am. Let's see. And Mr. Sleepa, am I saying that right?
Judge, can we be excused?
You may. Thank you. I'm
Thank
sorry.
you so much.
Yeah.
Okay.
Yeah, I have JP Morgan Chase and Bianca Rodriguez.
Yes, Your Honor, that's us.
All right.
Yes.
So Ms. Rodriguez is present. Mr. Silpa, is it Slippa or Silpa?
Silpa.
I'm sorry. Silpa.
That's all right, Your Honor. That's my last name's
these
butchered
doggone progressives. Like I can read, but on the screen it gets crazy. So I apologize.
It's okay, Your Honor.
I kept thinking it's Silpa, but I kept seeing Slippa. All right. So Mr. Silpa, on behalf of JP Morgan, this is a credit card case.
Yes, Your Honor.
JP Morgan's the originator.
Yes, Your Honor.
All right. So Ms. Rodriguez, what we're going to do is I'm going to hear from Mr. Silpa about what it is he's claiming that on behalf of his client is owed. And then you can tell me if you have any discrepancies, what he's saying, or if you have any arguments to say that you don't owe this amount of money or this money at all. Okay.
Yes, Your Honor.
All right, go ahead, Mr. Sopa.
Good afternoon, Your Honor. I promise you it'll be much briefer than the hearing you just had. This matter is extremely straightforward. JP Morgan Chase filed suit against Ms. Rodriguez to collect $5,993.65. Ms. Rodriguez was polite enough to file an answer, and in her answer, she admitted to every single one of our claims. Unfortunately, what she was offering was something we could not afford or could not do as a settlement, so we filed our motion for judgment on the pleadings based off of her own admissions.
All right. So $5,992.65, that's the total indebtedness, or is there court costs, attorney's fees, any of that?
It's $93.65. And
Yeah,
there are no court costs, attorney's fees. We're just seeking straight principal.
Oh, righty, that's good. Ms. Rodriguez, tell me what's going on.
I just wanted to, I was trying to come to an agreement for a lower payment amount because I'm not working right now.
Okay. So here's what the court does when I look at what they present, and then I look at your answer. And for your answer, if you don't present anything that says you don't owe the amount, or you dispute the amount owed, or there's some technical issue with respect to how the amount is presented to the court or how the lawsuit is presented to the court, then the court will give a judgment in the amount that they asked for. Now, I don't get into payment amounts or what you all agreed to with respect to repayment, but I will say this. There are many methods for collecting on a judgment. I don't get into that either. But you may, I understand that right now it's a hardship and you're not working, but I think it works in your favor a lot of times if you work with them to try and see, like, I mean, if you drive and Lyft or Uber, some portion of that can go to them or whatever your situation is, because the ways of collecting the money, there are many in Georgia, but if you were to get a job, then there's the possibility of a garnishment of your wages. They could attach a bank account or things like that. And I understand it is hard. What type of work do you do, Ms. Rodriguez?
I'm not working right now.
Well, when you work, what did you do?
I was in fast food. I was a cashier, then I got promoted to a supervisor.
Okay. Are you, and I don't want to get into your personal issue, but is there like a physical reason or a medical reason that you can't work right now?
No, I'm just home with my kids, taking care of them until my last one gets to an age where she can be in school, because right now we can't afford daycare.
I got you. Okay. So just between me and you, a lot of the counties are looking for people, and in some positions, they actually allow you to work from home. Now, you might have to train for a little bit before you can do that, but that in some situations is an option. And it's not very different from what you did at fast food. It just gives you more of a possibility of doing more in the future or making more money. Like, for example, our clerk's office. Our clerk's office is looking for people. They train you. They pay you better than fast food. You get benefits. You get sick leave. If you got kids, sick leave. Like I used to do Department of Labor. I used to be a hearing officer, and fast food. Everybody who works fast food, unless you're a manager, is part-time. You never get to the benefits, the pension, all of that. But if you start looking at some of these counties, and everybody's looking for people, especially since COVID, but some of these counties are desperate for people who can work. And a lot of I get that you don't want to do daycare right now. I get that. But a lot of times you can work part-time. They're willing to work with you. They need part-time people. They need full-time people. So that is an option if you can make that work. I'm just saying that. Because what you don't want, they're asking for principal only. You know what that means? That means they're willing to get rid of all the interest that could come. The interest usually on a credit card is 21 to 27% a lot of times. That's a lot of money. If they ask for that, it would expand your debt immensely. But what Mr. Silva's saying is his company is willing to just take the principal, which is very,
And we're
very
not, we're even willing to waive judicial interest. So we just
Yeah.
want principal.
They just want this amount of money. And so what I'm saying to you is if there is any way that you can make that work so that you can get on like a payment plan that would at least get you started. Because I promise you, some of the stuff I've seen where, you know, the contract asks for the principal, the interest, the attorney's fees, I mean, by the time they stack it on, you're almost owing twice as much or more. So I just say that. Now, because you haven't presented any other answer but hardship, which I get and which I understand, but it is not a legal relief. What I would do is go ahead and grant the judgment to Mr. Silpa's client, but continue to talk to them. And how old is your youngest?
She's 2.
Yeah, I know. Because I had to go back to work, I guess, when my youngest was like 8 or 9 months, and childcare is a thing. Affording it, you know, trying to find safe childcare that you feel comfortable leaving your child in the hands. I get that. It's hard on working mamas. But I say continue to speak with Mr. Silpa and his client to see if y'all can work something out. Also, if you're looking for something, nothing against fast food, but don't go back to fast food. Go someplace where you're going to get benefits, where you're going to get a pension, where you're going to get sick time. If you got stuff with your kids, if you're going to get vacation time. So these are times where you will still get paid, even though you have to take a day. Fast food doesn't do that generally. Okay?
Yeah. Yeah.
You got me?
Yeah.
All right.
Yes.
So take some deep breaths.
Okay.
All right. It's going to get better. Hopefully, if you get one of those jobs, it can, you know, when you're ready to get back into the workforce, it can turn some stuff around. You got me?
Yes.
Because I think a lot of times people just don't know. People don't know what's out there and what's available. But right now, as I sit here, because both the clerks are my friends, you know, they're good people. And I know they're looking for folk. And I know the clerks in other counties are looking for folk, not just Clayton. I know every local government has positions that are open where essentially, you know, a lot of it is paperwork and data entry and answering the phone, but it's essential work for a government. Okay?
Yes, ma'am.
And it's going to treat you better than fast food. You got me?
Yes, ma'am.
So don't assume that's not something that's available to you. All right? There used to be a lot of the ladies who had 30-year careers in the clerk's office. They came right out of high school at like 17, 18. As soon as they graduated high school, they went into the clerk's office and retired young and still looking good, retired young with a pension and 30 years of experience in something that is really, really valuable. Okay?
Yes, ma'am.
So I'm going to go ahead and grant the judgment, continue to speak with Mr. Silpa and his
Please
client.
do reach out.
And
We
see if y'all
have several
work something
options
out.
available to you, and we're happy to work with you. But
All right.
you got to reach out to us.
See, Mr. Silpa's, he's cool people. He's not bad.
Yeah.
He's not a bad guy. So, but take a deep breath. And like I said, when you get back into the workforce, look at some options that are going to give you more than just a paycheck. Okay.
Okay.
There's nothing like having a pension when you get ready to retire and sick leave and vacation time.
Yes, ma'am.
Okay.
Yes, Your Honor. Thank you.
You're
Thank
welcome.
you, Mr. Silva.
All right.
I'm happy to help. I'm very empathetic to your situation. Believe me, I got 2 little ones of my own, so I understand the struggle with childcare.
Yeah.
Okay, thank you.
All right. Thank you, Mr. Silva. Thank you for your patience. Thank you, Ms. Rodriguez. Thank you for your patience. Both of you will get a copy of my order. I think that's all that we have for the calendar.
Thank you very much, Your Honor. You have a good day.
For a
All right,
moment.
take care. Yeah, I'll call you, Ms. Powell.